Good afternoon. My Collaborative Teams CollaborEAT Live series is a 10 to 15-minute video conversation on Facebook Live and YouTube. It takes place every Wednesday at 1 p.m. Eastern Time, and you can either join us when we're live or watch it at your leisure. CollaborEAT Live provides digestible content to both professionals and the public on a variety of topics relating to the collaborative process. Our CollaborEAT Live episodes consist of a variety of topics that are driven by our followers and our members. Topics range from ethical considerations, best practices, problem solving, marketing, and specialized topics relating to the collaborative process. It includes practice tools and more. Whether you join us live or watch us in your free time, you can count on our weekly CollaborEAT Live to provide you with thought-provoking conversation and educational information about the collaborative process. And we are very fortunate today to have Professor Robert Merlin, who has mentored many of us in the collaborative process, including me. Bob is known for helping clients reach settlement, both through the collaborative process, through mediation, and through other out-of-court processes. He's committed to helping his clients resolve divorce and other family law issues in the least adversarial ways possible. Advocating for the best interests of the entire family, Bob applies his skills in the collaborative law process and uses direct negotiation and mediation to assist his clients in attaining agreements and staying out of court. A very experienced collaborative attorney, Bob continually hones his skills in the collaborative process. He's a trainer of other collaborative professionals and has a very long history of community involvement, both in the collaborative world and out. Welcome, Bob. It's such a pleasure to have the opportunity to interview you on something that you have educated me very specifically about, and that is the Uniform Collaborative Law Act. So let me start by asking you, since I joined the committee under the International Academy of Collaborative Law Professionals, thinking that I was joining something relating to UCLA out in Los Angeles, and having no idea what the UCLA is. So why don't you tell us a little bit about what it is?
Well, thanks, Becky. It's always great to see you and talk with you someday in person. The Uniform Collaborative Law Act is a uniform law that was created by the Uniform Laws Commission. It's a national organization in the United States that creates laws that are then given to the states. They have an opportunity to adopt the uniform laws. So for instance, the Uniform Commercial Code is from the Uniform Laws Commission, and that governs so much of our economy, the negotiation of checks and negotiable instruments. There's a Uniform Mediation Act, a Uniform Probate Act, all sorts of acts. Right. So in 2009, the Uniform Collaborative Law Act was created. It was in statutory form, all statutes. The commission learned that that was not going to work in a lot of states. In fact, the majority of the states require that the regulation of the practice of law is done by their highest court, not by the legislature. So these are acts that are given to the legislatures in the states to adopt. So then they, in 2010, created a mirror image of the statutes in rule form. So now it's the Uniform Collaborative Law Rules and Act, and the states have an opportunity to pick and choose what they want to adopt, and they adopt the specifics of the uniform statute and rules to meet the needs of their state. The act has been adopted in 20 states and the District of Columbia as of when we're discussing this. Virginia was the most recent state to adopt it. The states are also given an opportunity to adopt it across the board in all of the laws, or to limit the scope to family. The majority of the states have limited scope to family. But I can tell you that North Carolina had a pre-Uniform Collaborative Law Act on collaborative, and then last summer they adopted the act applying to everything else. So now they have it in civil as well as family.
Interesting. And I know you were very involved and instrumental in getting the Collaborative Law Act passed in Florida, but I don't believe it followed the Uniform Collaborative Law Act. I believe it stands as its own statute outside the Uniform Collaborative Law Act. Is that correct?
Well, what happens is the state takes the Uniform Act and decides what they're going to take, amend, reject. So Florida absolutely is based upon the Uniform Collaborative Law Act and rules. And a lot of it is the exact same language. Some of it is different language based upon our needs. So for instance, in Tennessee, they adopted everything in rule form. In Florida, we have an act, we have a rule of procedure in the family law rules, which governs what happens when a matter goes from litigation into the collaborative process and then back into the litigation, or goes from the collaborative process into litigation. And then we also have an ethical rule for attorneys that governs, it's specifically addressing the collaborative process. And all of that was basically taken from the Uniform Collaborative Law Act and rules.
And how does a state or a group of individuals like yourself go about getting the Uniform Collaborative Law Act enacted, or statutes and rules that pick up pieces of the UCLA in their own states?
The Uniform Laws Commission has commissioners in each state, so theoretically they can help professionals in a state work on getting the act and rules adopted, but as a practical matter, that's not going to happen. In Florida, the commissioner, one of the commissioners here, offered help, but really didn't do anything, and we didn't need his help either. It really takes a group of people, in this case, collaborative professionals, who are dedicated to getting it done. And you have to know about the political process. You have to know about the political winds that are blowing in the state. What is the best way to get this adopted? So in Tennessee, they decided that they were much better off just having rules and not even bothering with the legislature. In other states, such as Pennsylvania, they came to the exact opposite conclusion. So they didn't bother with the courts. They did everything in the legislature. And there's no right or wrong way. It just depends upon what's going on in your state. But it does take a lot of work. I spent 10 years working on it.
And what are the benefits to collaborative professionals having a statute or rules enacted in their state?
It provides uniformity throughout the state and between states. So as we become a more global community, especially as a result of the pandemic and matters being handled virtually, we have interstate divorces and family matters. Maybe there's an interstate prenuptial agreement that's going to be handled collaboratively. So having the same rules and procedures in multiple jurisdictions helps it become a uniform process. In Florida, I can tell you that before the act was adopted, an attorney called me and said a woman called her and told her the following story. The woman said, my husband and I went to an attorney. The attorney said that she could use the collaborative process and help both of us. The clients were completely ignorant. Needless to say, one attorney cannot use the collaborative process for both attorneys. That is a violation of the Florida ethics. So they went through this process, signed an agreement, and then the woman got served with something that was filed in court by the attorney on behalf of the husband. And the attorney called the wife called the attorney and said, wait, what are you doing? You're my attorney. And the attorney said, no, I'm not. I'm your husband's attorney. Multiple ethical violations. That cannot happen under the laws now in the state of Florida. The Uniform Collaborative Law Act provides specifically that each party must have their own attorney, there must be a signed agreement, and there's a disqualification from representation in court should the process be terminated. Without these procedures and statutes, if a process breaks down, who's going to stop an attorney from going into going into court and representing a party when the process was terminated?
I have two questions. First, for jurisdictions that have administrative rules relating to the collaborative process, how does having the UCLA or a specific statute and rules relating to collaborative law impact those freestanding, if you will, administrative rules that are in the county?
So in Florida, there are a number of circuits that have administrative orders, and they were entered before the Uniform Collaborative Law Act was adopted. And they address basically the same rules and procedures that are followed in the Act in Florida. But there's a question about what's enforceable, what's not enforceable. I think the way they're written in Florida, they're enforceable as well as the statutes and statewide rules. I can tell you that, at least in South Florida, the vast majority of family attorneys don't even know that there's an administrative order. So, and the judges don't know either. If there are truly administrative rules in a state so that they're basically statewide, then there has to be some type of coordination when the Uniform Collaborative Law Act and rules are being considered. And maybe whatever is new is going to take the place of the old, or maybe it's going to amend it. I think the vast majority of states do not have statewide rules or statutes until the Uniform Collaborative Law Act and rules are adopted.
So two questions to follow up to that issue. Is it worthwhile in states where there are statutes or the Uniform Collaborative Law Act has been adopted? Is it worthwhile to even waste time trying to get administrative orders adopted by the circuits? Number one. And number two, in the states where there is no statute or rule, would that be a route for those states to go to try and get something implemented at the local level?
Well, I can tell you that in Miami, we talked to the chief judge about adopting an administrative order because there was no statute and the rules weren't adopted yet either. So at least in our jurisdiction, in this circuit, there was a process that was supposed to be followed, and it mostly addressed what happens if a process breaks down and comes back into litigation, or if it goes from litigation into the collaborative process, how to stay a pending matter, et cetera. Ask your question again.
I was wondering if for states that, well, there was a two-part, and then I have one more, and then we actually have to wrap up because we're reaching our limit. For those circuits that, like in Florida, for example, where we already have a statute, is it worthwhile to even bother trying to get administrative orders adopted? A, and B, for states that have nothing, is it worthwhile for them to try and get at the local level administrative orders adopted? And then I want to wrap up with what do we have to offer through the UCLA Committee of IACP to those states that need help getting it adopted?
Okay, so for a state that has the statute, the UCLA, having administrative orders can help because in a local jurisdiction, you can supplement the Uniform Collaborative Law Act and rules. So for instance, I created a standing order and form to be used in a circuit that requires the parties and attorneys to acknowledge that they are aware of alternative dispute resolution methods, and it encourages them to use that before they go to court. In states where there is no, the Uniform Collaborative Law Act and statutes has not been adopted, getting an administrative order may be the first step, and it may be much easier to do something locally than to do it statewide. You can talk to a chief judge and say, Judge, educate the judge. This is what the collaborative process is about, and sort of sell them on the benefits to the system, to the courts, of having certain processes followed. Excellent. And then as far as people getting involved in the Uniform Collaborative Law Act advisory panel of IACP, we have plenty of room for people to volunteer. You will learn about the Uniform Collaborative Law Act, if you're working on or contemplating working on adopting it in your state, this is a great way to get educated and to have a seat at a table where there are multiple people who have worked on the adoption of the Uniform Collaborative Law Act in their respective states. As chair of the task force, I really would love for more people to get involved. And as someone who has been integrally involved in the last 3 years, Becky, you need the help as well. So we welcome more people to join IACP and join our task force.
And I'll wrap up by saying it's a great committee. You've done an incredible job of leading it. And it's actually a lot of fun because it's an intellectually driven committee and we learn a lot from it. So thank you, Bob. I've been told we have to wrap it up, even though we could go on for an hour. If you would like to be a guest on CollaborEAT Live, email us at info@mycollaborativeteam.com or reach out to us on social media. Bob, always a pleasure. I look forward to seeing you live since I see you on Zoom at least twice a week. All my best. Thank you for joining us today.
Take care. My pleasure.